Mr. Chief Justice, and may it please the Court. The President's constitutional duty to execute the law does not give him the power to violate that law with impunity. But petitioners claim that the President was free to fire Commissioner Slaughter without cause in violation of the FTC Act as authoritatively construed by this Court. And, they urge, even if that firing was illegal, there is nothing that any court anywhere at any time could do to remedy that violation. The District Court correctly rejected both arguments, and its judgment should be affirmed.
The question of the President's duty to execute the law is both fundamental to this case and to showing the misunderstanding of the law by attorneys and justices alike.
On the merits, multi-member commissions with members enjoying some kind of removal protection have been part of our story since 1790. So, if petitioners are right, all three branches of government have been wrong from the start. Congress and prior presidents have been wrong to jointly create early founding-era commissions and more than 24 traditional independent agencies since 1887. And this Court was wrong to repeatedly bless those laws and to unanimously uphold the exact same removal provision at issue here in Humphrey's Executor almost a century ago.
Except the legislation creating Sinking Fund, as it was eventually called, does not put any protection on the members in power to spend the money. It does create a group, which many called a commission, made up of members, not all of which are part of the executive branch. The purchase to be made of the said debt shall be made under the direction of the President of the Senate, the Chief Justice, the Secretary of State, the Secretary of the Senate, the Secretary of the Treasury, and Attorney General for the time being. Now, Mr. Agarwal then moves his argument to history, precedent, and stare decisis.
Finally, stare decisis militates against overruling a century of precedent at this late date. The political branches are more than up to the task of finding reasonable legislative solutions that strike an appropriate balance. That kind of legislative solution is far preferable than abandoning a foundational precedent on which so much of modern governance is based. I welcome the Court's questions.
The justices had many questions for Mr. Agarwal about the ability of Congress to create agencies with different powers, conclusive versus preclusive, that would determine if they were under the control of the President or not. Mr. Agarwal frequently referred back to the court precedent. Since Mr. Agarwal is so interested in stare decisis, let's start our analysis there.